In a rare 9-0 ruling from Canada's Supreme Court, the justices for once took the side of the exploited and the vulnerable, ruling against pimps and affirming Canada's Nordic model, opposing the sex trade. The Canadian Supreme Court actually upheld the country's prohibition on inducing or profiting from the sale of sex on July 24. In a very stern judicial rebuke to advocates of so-called sex work, all 9 justices affirmed, in a case referred to as R.V. Klobuchar, the prohibitions to the Criminal Code of Canada, the 2014 Protection of Communities and Exploited Persons Act. To give you a bit of background on this legislation, it has a boring name, but it's actually really important. This act adopted the so-called Nordic model for combating the sex trade. And what it did was it criminalized the purchasing of sexual services or advertising the sale of sex or purchasing sexual services or pimping. And so what this does is it essentially shifts the criminal penalties from the selling of sex, prostitution, to purchasers and pimps. And the reason this is called the Nordic model is that this legislation is targeted towards reducing the exploitation of vulnerable women and girls. And what would happen when you merely banned prostitution is these girls or these women would be arrested and then they'd be picked up on the corner outside the jail by their pimp and they'd be trafficked all over again. Whereas if you shifted all of the criminal penalties to the pimps and the purchasers, you reduce prostitution, rescue vulnerable and exploited women, and at the same time, you're having a far more wide-reaching social effect. So this case stated that, the legislation, stated that prostitution is inherently exploitative, which is significant, due to the harm caused by, quote, the objectification of the human body and the commodification of sexual activity, which in my view could later be used to take action against the online porn industry, since the world's largest porn company is actually based out of Montreal. Here's how the Christian Legal Fellowship summed up the Nordic model. They've got a good summary here. This approach has also been adopted in Sweden, Norway, Republic of Ireland, Iceland, France, Northern Ireland, and endorsed by the European Parliament, the Council of Europe, and the UN Committee on the Elimination of Discrimination Against Women, affirmed by the UN Special Rapporteur on Violence Against Women and Girls, which, by the way, they're also very anti-porn, some rare good stuff from the UN there, and upheld by the European Court of Human Rights, as well as the Alberta Court of Appeal and the Ontario Court of Appeal. Now, pro-prostitution activists claim that the sex trade constitutes legitimate sex work and is not exploitative, and they've long objected to Canada's Nordic model on those grounds. And as CLF, Christian Legal Fellowship, reported on January 24, this was a key argument they advanced in Klobuchar, which involved 2 men convicted under the law's provisions as parties of obtaining a material benefit from sexual services and procuring a person to offer or provide sexual services. Now, what does that legal jargon mean? Basically, it was 2 men. They were pimps. They served as drivers for prostitutes in Calgary. They were arrested and found guilty by an Alberta court of benefiting financially from prostitution, as well as being parties to procuring women for prostitution. So they won at trial, but an Alberta Court of Appeal overturned their decision. They appealed, and that's how their case ended up at the Supreme Court. The Supreme Court giving a 9-0 ruling against these men is very significant. They rejected claims that Canada's Nordic model is unconstitutional, and instead they affirmed the constitutionality of our law, banning the sale of a person's sex acts, and even noted, quote, in situations that might not appear to involve a specific act of exploitation, which acknowledges Parliament's conclusion that commodification and thus exploitation results from the fact of profiting from the sale of another human being's sexual activity. And the court explicitly recognized the contributions of interveners that emphasize this fact in paragraph 163. And this is a great paragraph here, so I'll summarize it for you. In forceful submissions, the intervener, the Women's Equality Coalition, consisting of the Vancouver Rape Relief Society, Concertation de Lutte contre l'exploitation sexuelle, the Aboriginal Women's Action Network, Formerly Exploited Voices Now Educating, London Abused Women's Centre, and Strength and Sisterhood rejected the appellant's promotion of prostitution as a solution to women's economic inequality. The intervener particularly rejected the cruel logic that the overrepresentation of the most marginalized women, including Indigenous women, in the prostitution industry is akin to an employment equity program rather than a reflection of profound sexism and sexualized colonialism. So these pimps basically argued that the fact that there's so many Indigenous women in sex work represents the equitable nature of the sex trade rather than the exploitation of particularly vulnerable people. And they were strongly rebuked by justices from the bench. And it's so rare that we get a good ruling from the Canadian Supreme Court, and even rare when we get a unanimous ruling. And Canada's Nordic model genuinely protects people from human trafficking, from exploitation, and targets those who profit from the sex trade. And so it's a great piece of legislation. I would say a key part of Stephen Harper's social policy. And so the fact that it was upheld by such a wide margin is a rare piece of judicial encouragement here in Canada. And so it was the Supreme Court's first ruling on the constitutionality of the provisions of our Nordic model and affirmed lower court judgments. And it indicates that the legislation is likely to stand long term. It was also a rebuke to advocates of the sex trade and an affirmation, which is very important, of the inherent exploitative nature of the sex trade. Now, pro-prostitution activists are predictably, very outraged by this decision. 23 advocacy organizations for the sex trade have called for the overturn of Canada's Nordic model. And incidentally, Joyce Arthur of the Abortion Rights Coalition of Canada is a very vocal supporter of what she calls sex work. She actually worked briefly as a stripper herself. And with the Supreme Court's July 24 ruling, it appears that the advocates for the sex trade are out of options. And so, despite the depressing nature of the first story that we covered on the Bridgehead briefing, this rare win is good news for the victimized and the vulnerable. It's good news for women and girls being exploited by the sex trade, and it's good news for Canadian society at large. And we sure do need it these days.